Quorum before we can get going here.
Awesome. Thank you very much. This should be quick. I think I have two witnesses, but my portion will be relatively quick. I see Chair Kelly, but with an empty chair.
What's that?
Chair Kelly with the chair, the red chair.
Yeah, no comment.
We're live streaming and ready to go.
Okay, well, we have a quorum. Welcome to the Senate Finance Committee today, March 17th, St. Patty's Day. And for members of the committee as well as the public, we've got 8 bills on the calendar. I'm going to go through the chronology right here. We're going to start with Senate Bill 912. That's the first bill. And then we're going to go to Senate Bill 894, Bill number 2. Next up will be Senate Bill 914, which is in the 3 spot. Fourth up will be Senate Bill 903. Next is Senate Bill 848. And then next, 6th bill will be Senate Bill 908. And then finally, we've got in the 7th spot, Senate Bill 728. And then last bill of the day, the 8th bill will be 727. And the rules for everybody is going to be the same. Essentially, the sponsor has unlimited time to explain the bill. And then we move to the sponsor's designated lead proponent, and they get 5 minutes. And then everybody after that gets 2.5 minutes. So with that, we're going to start today's hearings with Senate Bill 912. We've got Chair Smith here visiting from JPR. And Senator, you have unlimited time to explain what Senate Bill 912 does. So you're on.
Excellent. Thank you, Mr. Vice Chair and members of the committee. Good afternoon. I will be quick. Will not take unlimited time. I've got 3 panelists, Mr. Simpson, Mr. Renner, and Mr. Gagliardo, that can help explain some of the mechanics and the practical implications of the bill. But for the record, Senator Smith here to present Senate Bill 912. The problem that this bill seeks to alleviate or address is that a statute exists to provide employees with the right to ask for back pay, restitution, but when they do so, some employers, and this happens commonly within the restaurant industry and the agricultural industry, retaliate against those employees who file those claims or even participate in the proceedings. So current law allows for the Attorney General and the Commissioner of Labor and Industry to pursue cases against employers if they believe they have unlawfully withheld wages. It allows for a court to award reasonable fees and costs to employees, but not the Office of the Attorney General, who could step in for the plaintiff here. So it doesn't provide any protection from employer retaliation, however, and that's primarily what this bill seeks to remedy. So essentially what the bill does, it keeps the employees' names confidential so as to prevent the retaliatory actions. The bill prohibits an employer from taking adverse action against an employee who takes specified actions, which are kind of enumerated in the bill for wage payment and collection law. Some of the other statutes around the nation that have done this. So California protects employees from termination and other forms of retaliation. Arizona, Florida, New York, Oregon, and Washington, D.C., they all have the strongest protections. And some of those key elements have been pulled from those statutes and put into the bill before you today. So Maryland now has fallen in line with states like Arkansas, Kansas, New Mexico, Oklahoma, Pennsylvania, in that our retaliation protection only covers criminal penalties for employers who retaliate against workers and wage theft. So that's the general problem we're trying to address. That's how the bill goes about doing it. Happy to discuss the mechanics and particularities of the bill. But with that, Mr. Vice Chair, I'll rest and turn it over to my esteemed panel and stand by for questions.
Okay, why don't we, before we turn it to your lead proponent, any questions for Chair Smith? Why don't we get that out of the way in case he needs to bump back? Any questions for the sponsor? Okay, seeing none, we're going to go to your lead proponent, Tom Gagliardo. And Mr. Gagliardo, you, as the designated lead proponent, you get 5 minutes to articulate your views, okay?
Thank you, Senator Feldman. Let me introduce myself by telling you that I'm the former president of the Maryland Employment Lawyers Association and the chair of the Maryland State Bar Association Labor and Employment Executive Council. I'm not here to testify on behalf of those organizations, I'm telling you that, one, so you know that who I am, and to tell you that I have witnessed the problems that this bill will correct. I have heard the testimony of any number of lawyers who practice in this particular field. I do not explain how they have met with clients who will not pursue their legitimate claims for wage theft, unpaid hours, denial of overtime, or similar kinds of deprivations because they're afraid that they will be fired. And they'd rather sacrifice that which they are duly owed for fear that if they assert their rights, they will lose their job entirely. Now, I might point out two things very quickly. The first is, of all the workplace justice legislation that exists in Maryland, this is the only bill that does not provide a prohibition against retaliation. It's a simple matter of justice. Nobody's for retaliation. Nobody would come before this committee or any other and advocate for the right to retaliate against an employee who exercises a right conferred by this General Assembly. And it's just a matter of simple justice to correct this omission. Now, this bill was actually passed by the House in 2014, and the Senate Finance Committee at that time gave the bill a favorable report. But here we are nonetheless, 7 years later, still asking for simple redress for the most fundamental protections in the workplace. I have submitted written testimony, so I'm not going to take all my time and go over this over and over. I do want to make one point about attorney's fees, which is provided for here. It costs the same amount of money. It takes the same amount of energy. It's the same amount of commitment if you pursue a claim for $100 or $1,000 or $10,000 or $100,000. And the most frequent victims, I really don't want to use that word, but the most frequent victims of wage theft are people at the lower end of the economic scale. They have the smallest claims and they have the toughest time finding attorneys to represent them. This bill provides and empowers the Attorney General, and it empowers private practitioners to do justice by people whose wages have been stolen from them. I can't think of a simpler statement than please give this bill a favorable report in the interest of justice, in the interest of fairness. Thank you.
Thank you. Thank you for your testimony. Any questions for the witness, Mr. Gagliardo? Okay, well, thank you, sir, for your testimony. We're going to go to the next witness.
Thank you, Senator.
Jeffrey Simpson signed up favorable as well. Mr. Simpson, you've got 2.5 minutes.
Thank you, Mr. Vice Chair Feldman. I'm an attorney with the law firm Webster and Frederickson, and I'm here on behalf of the Metropolitan Washington Employment Lawyers Association, which is a group of about 300 lawyers or 400 lawyers, many or most of whom live or practice in Maryland. Our members advocate on the behalf of employees who feel that they've been the victims of discrimination or the victims of wage theft or the victims of retaliation for speaking out when they see a workplace wrong. And we're here to redress that last issue because there's a gap in the law, as Mr. Gagliardo and Senator Smith has said. All of the discrimination laws in Maryland, to which I'm aware, and federal laws, make it illegal to retaliate against people for speaking out. And there's a good reason for that. And there's a reason why the Supreme Court has held that the prohibitions on retaliation are often broader than the actual discrimination. And that's because you can't enforce the law if employees are chilled from raising concerns. There would be no anti-discrimination law functionally if every time a woman experienced sexual harassment and she wanted to complain about it, that she was choosing between enduring that and being fired for speaking out. And the courts have recognized this. And so but the Maryland Wage Payment Collection Law does not recognize this. So the prohibition on, the lack of the prohibition on retaliation makes the laws that this assembly has passed toothless. And I can say, just as a matter of personal experience, is that I have not once had somebody come to me and say that I'm going to choose to fight over this few $1,000s of underpayment if it's going to cost me my job. Not once in my career. I've had people come in after the fact and say, hey, look, I need to sue because I've been stiffed on my commission. I haven't been paid in the timely manner as required by the law, but never have they said, I'm going to pursue this claim if it means I lose my job. And that's what this bill is here to redress. And for that reason, I urge the committee to give SB 912 a favorable report. Thank you.
Okay, thank you, Mr. Simpson. Any questions for Mr. Simpson? Okay, seeing none, we're going to go to the next witness, Richard Renner, who's also signed up favorable. Mr. Renner, I do see you there, and you also have 2.5 minutes.
Thank you, Senator Feldman. I'm Richard Renner. I'm a partner in the DC law firm of College Harvey, Chusey, Newman, and Fitch. I'm also a volunteer with the Montgomery County Bar Association Pro Bono Program and the Washington Lawyers Committee Workers' Rights Clinic. I previously worked for the National Whistleblower Center and for Casa de Maryland. I'm testifying today for the Maryland Employment Lawyers Association. I live near Wheaton in District 19. At CASA and at the pro bono clinics, the most common employment problem by far is wage theft. And workers who don't have unions sometimes have to delay or forgo payment of their wages just to hold on to their job and keep working. The DLLR is swamped with more complaints than they can handle. And at these clinics, we try to help with demand letters and referrals to small claims court. But there are very few lawyers who will take these cases because employers tend to fight hard and judges are reluctant to make a fee award that's so much greater than the amount of money at stake. A common question we get in these wage theft cases is, will I get fired? And I wish I could just say no. But Maryland law has been ineffective at deterring this most obvious form of retaliation. And I'm so pleased that Senate Bill 912 here is poised to correct that problem. I'm particularly pleased with its use of a modern causation standard. This, in paragraphs D3 and D4, it uses the bifurcated contributing factor and then the affirmative defense of clear and convincing evidence standard. That's the same that's
Is Mr. Renner, Mr. Renner, somehow we lost your audio. I'm not quite sure.
Oh,
Okay, there you go.
okay, thank you.
Yeah.
So this bifurcated causation standard is one that's commonly used in federal whistleblower laws, like the ones that protect transportation workers, food safety concerns, and whistleblowing in federal workplaces. It'll be a significant tool here for us practitioners to redress retaliation when workers stand up for the right to receive the wages they earn. So I urge this committee to hold a vote on Senate Bill 912 and send it to the floor for enactment. Thank you so much.
Okay, thank you for your testimony. Any questions for Mr. Renner from the committee? Okay, seeing none. We're going to go to the final witness, the lone witness signed up, unfavorable, Champ McCall. Champ, you got to unmute yourself. Okay, and you got 2.5 minutes.
Thank you, Mr. Vice Chairman. I'm amazed that I'm the only opponent, but
Well, let me be clear, the only opponent that signed up to testify orally, there is written testimony.
Okay, so I'm the one with the courage of my convictions. All right, that's fine. With respect to the fundamental thrust of the bill, which is to prevent employers from retaliating, we don't have a problem with that. Conceptually, that's fine and appropriate for all the reasons that have already been stated. It's individual items within that process that are outlined in the bill to which we have objection. You've got lengthy written testimony of mine, and I would save you the burden of having to listen to me reiterate all that. However, there are some very essential points. Number one is on page 2 in lines 17 to 19, the apparent authority amendment to existing law. That is an invitation for miscommunication. Workers know who their bosses are, and there's no reason to interject uncertainty where certainty is appropriate. Secondly, the provisions on page 3 in lines 16 to 18 that deal with an employer's suspecting or believing that an employee may do something else. Now, how in the world is an employer ever going to defend an action if the claim is, oh, well, you knew secretly in your mind that I was going to do something to disclose inappropriate workplace behavior? That should simply be stricken from the bill. Thirdly, despite what the previous witness said, the idea of having unequal burdens of proof is entirely inappropriate. This isn't a whistleblower situation. This is a situation where you've got very straightforward workplace rules and regulations. They're very straightforward if the bill passes, provisions for what constitutes retaliatory behavior. The burdens of proof ought to be equal on the employee and the employer. That is simple justice and fairness. Lastly, the notion that an employer must have been an evil person because 6 months later something happened is, again, not appropriate. If there is a failure of the employer to adhere to appropriate work rules and regulation, then that's a new claim and it gets litigated. It isn't an automatic, well, you're guilty, now prove yourself to be innocent. And that's what this bill does. So for those specific reasons, and for all of the other reasons set forth in my written testimony, I would urge the committee either to adopt the amendments which are in my written testimony, or failing that, to give the bill an unfavorable report. And I'd be happy to answer questions.
Okay, thank you for your testimony. Senator Hershey, you got the first question.
Thank you very much, Mr. Chairman. And Champ, I just wanted to, again, thank you for being here. As the Vice Chair said, there were a number of others that opposed the bill that did not sign up to be oral testimony. But your documentation here of 3 pages is very specific on a number of the concerns with the bill. I just, again, wanted to thank you for putting that together in such detail, and just urge my colleagues to make sure that they see this as we further debate and analyze the bill. I appreciate that. Thank you.
Thank you, Senator.
Okay, any other questions for the witness? Okay, seeing none, that concludes the bill hearing on Senate Bill 912, and we will now move to Senator Rosapep. Senate Bill 894, and I do see Senator Rosapep in the House. And Senator, you have unlimited time to explain Senate Bill 894 before we move to your lead proponent. He's going to get 5 minutes after you, but Senator Rosapep, 894.
Thank you. I assure you, I will not take unlimited time. And I also want to promise you, this is the last bill I have before your committee this year. So St. Patrick's Day, we should celebrate. So this is sort of a big bill. And again, it came out of the work group that included Senator Augustine, Senator Hayes, and Senator Bidle, dealing with the COVID crisis. And the COVID crisis work group basically focused on 2 things. One were the health issues, and the other were the economic issues. And this comes obviously from the economic side. Getting people back to work obviously requires testing, tracing, and vaccinations, which you passed our bill earlier this week on testing and tracing and vaccinations. And I think we have passed it out of budget and tax, so that's moving forward. This deals with the job side of it. The good news is that because the Federal Reserve Board is taking a very pro-growth, pro-jobs position, as you know, keeping interest rates low, And because the federal government has passed this very large stimulus package, which is not just about health, it's also about economics, and because we expect President Biden also to be proposing a major infrastructure proposal probably in the next couple of months, definitely this year, the focus will start shifting to jobs and work and stimulating the economy. And so what this bill does is say, let's do our part. And the good news is with federal money. So the bill was drafted before we knew what the Biden stimulus package was going to be. And so it has some weasel word language about use federal money if you can, but use state money if you have to. But given the fiscal support that all the states have been getting from the federal government, all of this can, and my judgment should be funded with federal money. So that's number one. Number two is, this is multifaceted. One of the largest constraints on growing the economy as we come out of the COVID virus will be the skills mismatch. And this committee has dealt with all kinds of legislation on the skills mismatch. Given that we have the money from the federal government, given that we have the need, given that we now have, unfortunately, a lot of dislocated workers in particular sectors, particularly hospitality, particularly the restaurant industry, and some others. This is a wonderful opportunity for them, a wonderful opportunity for employers who have shortage of skilled workers, and a wonderful opportunity for the entire economy. And that's what this bill is focused on. Post-COVID crisis jobs. It has four major components. Number one, it says that, as we've all learned, what we're doing right now is so many things we used to think could only be done on site can be done online. Well, that includes training. And so one provision of this bill basically says that everybody who does workforce-related training in Maryland, from colleges and universities to public schools, to apprenticeship programs, to private organizations, to our licensing boards, wherever it's possible to do the academic training online, we need to encourage that. So it says the policy is we want to make online training as available as possible. It also includes some money to help folks make the conversion for instructing folks in the academic side of stuff. Now, obviously in massage therapy, obviously in putting shots in people's arms, obviously in being a taste tester, you got to be physically with the product or physically with the patient. But most training, frankly, even in those fields, is what we would call academic. It's the theory, it's the math, it's the instructions, it's the system. That kind of instruction can be done online. Doesn't have to be done online, this doesn't require it, but it has to require that option. You'll hear more testimony from folks both in labor and in industry who feel strongly about that. So that's number one.
Hey, hey, Jim, before you go any further, not to interrupt, Sarah Augustine, you're going to take it from here. I got to go present a bill over in EHE right now, so I'll let you get to your second point, but I'm going to break out, and Sarah Augustine, you take it from here. Okay, guys, I'll be back.
We're going to miss you, Mr. Vice Chair, but I have great confidence in Senator Augustine. He's my neighbor. So thank you. So that's number one. Number two is we have folks who are unemployed who don't have some of the very, very basic skills they need to transition. And the basic skills are what have already been defined in our current legislation, what we call college and career readiness, which is basically the English and math skills to be able to work. Some of that is related to people who didn't learn to read well enough. Some of that's related to people who didn't learn to do basic arithmetic or multiplication or math well enough. And so there's a grant program in here to scale up basic education for folks who are unemployed in this recession. The third piece relates to the community colleges. And we all believe the community colleges have great capacity to help our workforce upgrade their skills. And so what this bill says is that the additional money that they will be getting over the next, I believe it's 3 years, I believe it's FY23 through FY25, 75% of the additional state money should be directed towards workforce skills. That doesn't say they can't do a lot of work with academic preparation of folks who want to go into four-year colleges. But for this period of time coming out of this crisis, it's a policy decision. We say to the community colleges, we want you to focus on workforce because of the need and the opportunity. You'll see testimony from the community colleges and from MACA where they say they don't like that, they just want to do what they want to do, which I understand. So that's a policy question as to whether we want to put more emphasis on workforce during this period of transition. And the last piece, which is the most important and the biggest, and it's based on a model that Australia actually has pursued for the last year, is to use this opportunity to move people aggressively into apprenticeship jobs. You all have dealt with this legislation over several years. You've worked with my bills, other people's bills. Apprenticeships have a great advantage over other kinds of job training because they are a job. You don't start the training until you have the job, which means you're not taking on debt. It means you are learning on the job. It means that your employer is invested in your success and you're invested in your employer's success. It's a win, 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 win. So what this provision does is essentially put a significant amount of money into subsidizing folks moving into apprenticeships out of the industries where they've been laid off. So this is focused on people who have been laid off during COVID. So it does not include folks who have not been laid off. It's focused on people who have been laid off, but there are a lot of people who have been laid off, obviously. So it's a big market. And then it focuses on those occupations and industries where we have the workforce shortage. We had them before COVID, we have them during COVID, we're gonna have them after COVID. And they are, and there are lots of studies on this. The Greater Baltimore Committee did a big study, but it's pretty easy to conclude just commonsensically. One is construction, one is healthcare, even more dramatic coming out of COVID, IT, and business services. The provision in here that also lets the Department of Labor and the local workforce boards identify other industries if they're niche industries that are not covered in those 4 buckets. But those are by far the big 4 buckets. And when somebody may say, well, how are you going to take someone who had been a waiter or waitress and put them into IT? Well, here's the answer to that. Simple example is a lot of IT is customer service. It's help desks. It's helping people solve problems. That's what waiters and waitresses do, is they listen to their customers, they understand their problem, and they help them. I use that as one example. Another example, which is lower skill, is folks who clean hotels, housekeepers, and people who clean office buildings. I mean, office buildings, as we all know, because of telework, there are fewer people going back to office buildings quickly over the next year, 2, 3, 4. And that reduces the demand for folks who clean offices. Well, now we have to clean schools a lot more. And I know in Prince George's County, our workforce board is specifically focused on that, is recruiting folks who have skills in cleaning buildings and focusing them on where the new demand is. So those are the kinds of things that 4th provision of the bill is designed to do, is to incentivize, subsidize, put money in fast to getting apprenticeship sponsors, employers to hire folks who are unemployed, train them through apprenticeship programs to be productive in those areas where we have skill shortages. And as I said at the beginning, the bill is not exactly written this way because it was written before the Biden package passed, but absolutely the intent, and I've discussed with the leadership and other folks, is to have this, all of this, to the extent you all agree to it, funded out of the federal money, the $2.9 billion that Maryland is getting from the federal relief package. Happy to answer questions. Thank you very much. I'm sorry I went so long.
Thank you, Senator Rosapap. Any questions from the committee? Okay, seeing no questions from the committee, we'll go to your lead witness, Mr. Joe Damatos. You have 5 minutes.
Thank you, Senator Augustine and members of the committee. It's so good to see you all here. You all know me as the president and CEO of the Health Facilities Association of Maryland. Today, later in this hearing, I'm testifying in that role. But right now, as the chief proponent of this legislation, I'm testifying in my role as chairman of the board of the Maryland Workforce Alliance. The Alliance is a 36-member association made up of trade organizations, labor unions, and apprenticeship providers. It's been my high honor to lead the group for the last 2 years, especially in our work we did with you on Kerwin in promoting trades and apprenticeships. Senate Bill 794 is an incredibly important bill. It would have been probably important pre-COVID. It is critically important during and after COVID. And it's important for all of the reasons that Senator Rosapap outlined. But I guess I would highlight one very specific thing. You know, Maryland does a bunch of things really, really well. Sadly, I don't think that we do digital learning well. And let me just really quickly define digital learning, because it is a phrase that's evolved. A couple of years ago, we were talking about online education. Well, digital includes online and virtual education, where people put on goggles and actually can learn hands-on techniques, both in the trades and in healthcare. Practicing surgeries, for instance, for surgeons before they're done, as an example. So why is that important? Well, we have a jobs mismatch that Senator Rosa Pepp outlined. And we have a great number of people, almost 30,000 of them by last count in Baltimore City, who have lost their jobs during this pandemic. And so Senate Bill 894 tees up the programs that Senator Rosa Pepp spoke about. But what it also does, very, very importantly, is that it puts on an equal plane involving community colleges, apprenticeship programs, employers. It puts on the same plane across industries, in-person training and digital training, both online and virtual. And in order for us to move forward in the most effective way, we're going to need all of that. Now, let me give you an example from my world, which is also included here in the MWA testimony. We have an amendment to Senate Bill 894 that I worked with SEIU on, and which SEIU supports. It's a perfect case study on why we need Senate Bill 894. So if you want to become a skilled nursing and rehab certified nurse's aide in Maryland, you have to do 100 hours of training, 60 hours in person with books, and 40 hours touching people. That's what it takes in Maryland to become a certified nursing assistant. And you have to pass an exam. There's no provision for doing that pre-COVID or currently, doing that 60 hours online. It has to be 60 hours in person. This bill and our amendment would allow people to do that digitally. More importantly, relative to this bill and why it's critically important now, and I'll make this final point, is this. During the pandemic, we were allowed under emergency orders in healthcare to employ emergency nurses' aides who earn their stripes saving the lives of Marylanders. And under Maryland law and under federal guidelines, 120 days after this emergency ends, they will no longer be certified nursing assistants, even though they've been working for the better part of the year doing that job. Our amendment will allow them to be certified nursing assistants as a stepping stone to still have to take the test to pass and become geriatric nursing assistants. So if I want you to remember three things about this bill, it'll help solve some of the workforce challenges and mismatches we had pre-pandemic. It puts on par digital learning with in-person book learning, which Maryland has lagged on. And finally, it'll be a tremendous resource to those who re-careered during the pandemic or who are going to need to re-career after the pandemic. Senator Augustine and members of the committee, I thank you for this opportunity, and I'm open to your questions.
Thank you, Mr. Damatos. I see the Senator Bottle has a question.
Thank you. Thank you very much, Senator Augustine. So, Mr. Damatos, thank you so much for speaking with us today, and particularly about the issue of CNAs and GNAs. It's something that I've followed very closely through the pandemic, and my Anne Arundel Workforce Development is all ready to work with you on this. So hopefully we can make it happen. They're already training a lot of CNAs, and they need additional funding and opportunities to do it digitally. So thank you so much for your comments today.
Thank you, Senator. Thank you for your partnership and support here and always.
Thank you, Senator Bidle. Any other questions from the committee? Okay, seeing no other questions from the committee, we'll move to the next witness, Mr. Bob Lerman. You have 2.5 minutes, sir. Mr. Lerman?
Yeah, okay, thank you very much. I'm Robert Lerman, Emeritus Professor of Economics. Here, I'm trying, okay, there we go. My testimony focuses on the apprenticeship component of the bill. And as Senator Roosevelt mentioned, apprenticeships are jobs, but I want to point out that they're fundamentally about learning, but not like just formal school. They're learning both academic, employability, as well as occupational skills. And they obviously improve the opportunities for rewarding careers. Just wanted to say one thing about, not only do we know that they're good for workers, and they're also good for employers because they improve retention and recruitment, deal with recruitment, and they're able to recoup a lot of the benefits that they are through the work of the apprentice himself or herself. But from a government standpoint, they're very different than funding individual, perhaps positions in community colleges, because once you get an employer to offer apprenticeships, that's going to set off a flow of funding, of training that the government doesn't have to pay for. So it gives you this long-term benefit of training. Now, unfortunately, just as several presidential administrations and governors have come to realize the desirability of scaling apprenticeship, COVID sharply reduced the need for workers and dealt a blow to hiring new apprenticeships. So that's why this bill on apprenticeships is so important and can overcome some of the COVID-induced impacts. Just to give you the scale of what we're talking about, currently there's just over 10,000 registered apprenticeships in Maryland, almost all in the buildings trades. This represents less than 1/3 of 1% of the workforce in Maryland, as compared to something like 2 to 3% in other countries. If it were 3% in Maryland, we'd be talking about 90,000. Even a 2% rate would be 60,000. Now,
Mr. Lerman,
yes.
if you could, you're at the 2.5 minutes. If you get to your final point, that would be wonderful.
Oh, okay. Well, let me just say, I think for a few recommendations, encourage performance-based contracting. If we did that with 4,000 per apprentice, we'd be able to double the number of apprenticeships. Number 2, allow public and private entities to help employers see the value and to market the apprenticeships with companies. And number 3, ensure that the Maryland State Apprenticeship Office is staffed sufficiently to speed up registrations and maybe use federal occupational frameworks as a kind of safe harbor to accelerate the registration process. And I will.
No, I appreciate your testimony, sir. Does anyone have any questions for Mr. Lerman? Any questions for Mr. Lerman? Okay, hearing none, that concludes the hearing. I want to thank everyone for coming for the hearing for Senate Bill 894. We'll now move on to Senate Bill 914. I see that the sponsor is here, Senator McCray. You have unlimited time on Senate Bill 914.
Wow, this is Corey McCray here for the 45th Legislative District for the Senate. Just was checking to see if I'm in the right committee. Good, Mr. Chair. I'm here on behalf of a very easy bill. It's a local bill that gives our sheriffs the right to collectively bargain. I won't belabor the committee with going into it, but I am joined by Sam Kojan from the Sheriff's Office, Frank Boston, who represents the folks, and Ms. Josephine Zellman, Mr. Chair, and just ask for a favorable report on Senate Bill 914.
Thank you, Senator McCray. Senator McCray, you have made your lead witness, Mr. Frank Boston, who will have 5 minutes. Mr. Boston?
Good afternoon, Mr. Chairman, members of the committee. I'm Frank Boston III. I doubt that I will take 1 minute. So I'll give the committee back 4 minutes worth of time. I represent the Maryland State Fraternal Order of Police, which is inclusive of the local lodge for the sheriffs. We certainly support this bill and thank Senator McCray for putting it in. It is a collaboration of work from the City of Baltimore, the management, which you'll hear from in the Sheriff's Department, the FOP, as well as the Department of Business, Department of Budget and Management. And all amendments were included, worked out last year, and everybody's on board. And we ask that you support this bill, which gives the local deputy sheriffs collective bargaining. With that, I'll stand for any questions and thank you.
Thank you, Mr. Boston. Members of the committee, is there any questions for Mr. Boston? Okay, seeing none, we'll move on to the next witness, Mr. Sam Cogan. Mr. Cogan, you have 2.5 minutes. Oh, I'm sorry, Senator Benson has her hand raised. Senator Benson.
Thank you very much. It's wonderful to see you, Mr. Boston, and thank you for your hard work. I really appreciate all that you do. I want you to know that. The question I want to ask is, what about the mayor and the council? Have you all had a conversation with them? Are they on board with this?
Yes, ma'am. Yes, Senator Benson. We brought everyone, Senator McCray brought everyone to the table. We had a work group. They are on board. We checked in with them this year, sent the bill around to everyone, and they are on board.
Okay, thank you very much.
Yes, thank you for the question.
All right.
Yep.
Thank you so much. Okay, Mr. Cogan, you have 2.5 minutes.
Thank you. I'd like to thank the committee. I am Sam Cogan. I'm the Assistant Sheriff of Baltimore, representing Sheriff Anderson, who is the sheriff. And I want to thank Senator McCray and the FOP for putting the bill in. I just want to let you know that the management is in support of this bill. It's a collaboration between the deputy sheriffs and the court security officers, the management, the city, and the senator for putting this together. I want to just specify that this is for the collective bargaining for benefits. This doesn't include disciplinary measures, which is something I know that's being worked out. This is just for the benefits. And I can take any questions. I'll be brief.
Thank you, Mr. Cogan. Are there any questions from members of the committee? Okay, seeing none, we'll move on then to Josephine Zillman Georgie. You have 2.5 minutes.
If I may, Josephine, you got to turn your microphone on, deputy, and your camera. Joe? She's kind of new with technology like I am, so.
Understood.
She's here.
Yeah, I saw that she was here.
Yeah, here she is.
She's trying to come now. Fair enough. We'll give it a moment.
We can.
She's the last witness for this bill.
Yeah, Joe, you just turned your mic off. We can hear you now. Just talk.
Did she submit, or she's strictly oral?
Yeah.
P Lodge 22?
Yes.
Now?
I see it at the bottom of the screen, but.
Yeah, it looks like she's having trouble communicating with us. Is there anything else that the sponsor would like to share? Perhaps that she was going to share with us, or what do you think, sponsor?
Just thank you for this opportunity. I won't belabor the committee. Just want to say that this was voted out of the delegation unanimously. It's a local bill. It's a local sheriffs. As the sheriff stated in reference to just benefits, collectively bargain. It's not disciplinary actions, and we're all on the same page. We're all moving in unison, and most importantly, our mayor is on board with this.
Yes.
Thank you, Senator McCray. Okay, that concludes the testimony on Senate Bill 914. And we will move on to Senate Bill 903. Senator Hester, I see that you are here. You have unlimited time to share with us about labor employment, traditional trade apprenticeship fund. Thank you.
Thank you, Mr. Chair. It's fun to be back in my favorite committee here. Esteemed members of the Senate Finance Committee, thank you for your consideration of Senate Bill 903. Each of one of us in our districts has our own little slice of important history, a unique built environment that's worth preserving. From Footer Dye Works in Cumberland to the Phillips Packing Plant in Cambridge, National Park Seminary in Silver Spring, or Fort Ritchie in Washington County, there's little slices of history all over the state of Maryland. Indeed, this year, Ellicott City is going to celebrate its Sasser centennial, 250 years of being Ellicott City. However, historic revitalization is often a difficult undertaking, and it requires unique skills on the part of the workers for that to be done correctly and efficiently. With unemployment at historic levels and a large number of individuals displaced by the COVID-19 pandemic, there is a need for workforce development programs in a variety of fields. Simultaneously, there is an opportunity to train people in fields like historic revitalization, where jobs, although specialized, pay well and support a good quality of life. This bill seeks to build on the successful model already working in Maryland to provide such opportunities for our constituents interested in a career in a traditional trade. Senate Bill 903 would create a traditional trade apprenticeship fund within the Department of Labor. This would be a special non-lapsing fund that would be used to distribute grants up to $50,000 to support apprenticeships where participants perform traditional trade work on historic preservation projects in the state. The parameters of the fund are modeled after the traditional trade apprenticeship program developed by Preservation Maryland in partnership with the National Park Service under the Campaign for Historic Trades. The program is designed to train individuals and place them in historic preservation roles with the National Park Service once they graduate. I think about this fund as similar to a scholarship fund. The actual apprenticeship programs would be run by an outside organization like Preservation Maryland, and the Department of Labor will only have to work with the registered apprenticeship programs to disperse the funds to the apprenticeship organizations to support those completing the training. Colleagues, with the federal Great America Outdoors Act supporting more than $3 billion worth of historic rehabilitation projects across the nation, we can expect to see a rise in investment in historic preservation projects in Maryland and beyond. We can use this influx of investment to train a new generation of traditional trades workers who will be prepared to maintain our historic properties for years to come. And in doing so, we can simultaneously complete important work here in Maryland to preserve our existing portfolio of historic properties, and we can bring good paying jobs to our constituents. There is a clear benefit to our constituents, our communities, and the history of the state of Maryland. And for these reasons, I respectfully request a favorable report for Senate Bill 903.
Thank you, Senator Hester. Vice Chair Feldman, you're back.
Well, why don't you can finish this hearing up and I'll take the next one. We're good.
Okay, sounds good. Any questions for the sponsor? Okay, hearing none, we'll go to your lead witness, which is Natalie Henshaw. Natalie Henshaw, you have 5 minutes.
Thank you very much. Hello, everybody. I'm Natalie Henshaw. I am the Historic Trades Program Manager for Preservation Maryland. I'm working on this campaign for historic trades. And thank you, Senator Hester, for introducing this important legislation. It's very exciting. I testify with experience as a traditional trades student, practitioner, teacher, small business owner, and a program manager. I have a variety of experience towards it. I originally actually hail from Oklahoma, and I had uprooted my life from Oklahoma to go attend a traditional trades program in Georgia. And that's because there wasn't a program in a 3-state radius of Oklahoma. And, you know, out that way, 3 states covers a lot of ground. It was a ways away. My actions were a symptom of a national crisis. In 1968, the National Trust for Historic Preservation issued the White Hill Report. This report was a call to action to train people in these traditional trades. Half a century ago, we knew there was a problem. And there's been a lot done since then to support historic preservation as a whole, things like tax credits, the creation of the Secretary of Interior Standards for Historic Preservation. But there has been little to no government support to actually train the workers necessary to fulfill these initiatives. As Senator Hester was saying, Maryland has a really long, vibrant history. And there's almost 1,500 listings on the National Register of Historic Places just in Maryland. I'd also like to add there's 27 national parks. And by contrast, my home state of Oklahoma has kind of 2 to their own to give a scope of the impact on Maryland alone. Buildings on the National Register required work done to the Secretary of Interior standards, but there's now no training to ensure that actual workers touching the building either know the standards or have the skills to achieve the standards. The going practice now is the architect needs to know those standards, and it's supposed to trickle down to the workers. I can testify as somebody in that position, it doesn't usually trickle down. Specialized training is needed for the compliance to this. SB 903 would support such training. Preservation Maryland has partnered with MPS on the Campaign for Historic Trades. Part of this is through the Traditional Trades Apprenticeship Program. We'll help place interns with the national park, and then it would lead to permanent employment in the national parks. But also it's to establish traditional trades apprenticeships with the Department of Labor. The campaign is coordinating these apprenticeships with existing preservation trade schools. So apprentices can work and earn an accredited degree in the process, so they can come out with a certificate or a 2-year degree in historic preservation. The initiative also focuses on diversifying the demographics of historic trades in construction. And the apprenticeship model in general, as somebody was previously saying, expands geographic and economic access to training. This is but one example of the type of workforce development that SB 903 would support, and it would place Maryland as a leader in this national movement. This legislation is multifacetedly beneficial. It helps traditional trades, economic development, neighborhood revitalization, educational equity, and workforce development. Additionally, it would also help both large and small businesses fill an employment gap of trained trades professionals. I thank you all for listening to what I had to say, and I urge the committee to return a favorable report. Thank you.
Thank you, Ms. Henshaw. Are there any questions from the committee for Ms. Henshaw? Okay, hearing none, we'll move on to Sarah Elizabeth Sasser. You have 2.5 minutes.
Good afternoon, members of the committee. My name is Lisa Sasser. I'm a historical architect, and I am a graduate of the National Park Service Historic Preservation Training Center Trades Apprenticeship Program. I'm also a member of the Preservation Maryland Board. For the last 35 years since going through the HPTC Preservation Trades Program, I have been involved in working on cultural resources all over Maryland, and also working in the traditional trades and as an advocate for the trades. As Natalie noted, Maryland has more than 1,500 National Register listings, including some 200 historic districts. These special places draw visitors from around the world and support countless local businesses while providing nearly $320 million in local and state tax revenues and generating $1.3 billion in economic activity annually. These special places demand a supply of tradespeople with the specialized skills to work on historic buildings. These skills are not found in contemporary construction, trades training, and education. Buildings on the National Register require work done to the Secretary of Interior standards, and specialized training is needed to ensure that work complies with these standards. While the stock of historic buildings increases every year, and shortages in this type of skilled labor have been extensively documented, going back to the 1968 Whitehall Report. Apprenticeship training will help alleviate that shortage, particularly for high demand, highly skilled workers. The Preservation Training Center, HPTC, in Frederick has been training traditional tradespeople since 1977. HPTC and Preservation Maryland are working in partnership to fully implement the Traditional Trades Apprenticeship Program. With the support of the Traditional Trades Apprenticeship Fund, the HPTC Preservation Maryland Partnership will allow these trainees to transition into full apprenticeships within the Maryland workforce. Employers will benefit from having pipelines of employees who are guaranteed to get supplementary education, improving their work quality. SB 903 would also benefit smaller employers who want to train young people, but don't necessarily have the funds or capacity to do so. These small businesses are often owned by highly skilled tradespeople who can pass on skills otherwise in danger of being lost. This bill would have a direct and
Ms.
positive
Sasser,
impact.
if you could get to it, pass it.
Yes, sir. As well as helping young people find new and rewarding careers, I urge the committee to return a favorable report. Thank you.
Thank you, Ms. Sasser. Any questions for any of the witnesses on the bill? Okay, seeing none, I'll turn it back to Vice Chair Feldman.
Okay, thank you.
Sorry, I take it back. There was one.
I'm sorry.
I apologize. Senator Kramer. You're muted, Senator Kramer.
Muted, Senator.
Thank you for that, Mr. Chair. I appreciate your indulging me and letting me jump in real fast. This is for the bill's sponsor. Could you share with me a little bit of information about the fiscal note, please?
Oh, yes. I'm so happy you asked, Senator Kramer. Thank you for that question. I think there was a bit of misunderstanding. The fiscal note that you see includes $179,000 the first year, going up to $200,000 in the fourth year for the Department of Labor to hire staff to run the program. The bill doesn't actually create a program. We create a grant which can be passed through to existing programs. So I really don't think they're going to require any additional staff. So the fiscal note should be zero. The scholarship itself would be money coming from the federal government. And we just need to create this grant vehicle to capture that federal money. Does that help?
It does. And would you maybe consider reaching out to the fiscal note writer then?
Of course.
See if you can get that clarified. Okay, that'd be great, because I think that'll be important for the committee when looking at the bill.
We'll get back to you on that, Senator. Thank you so much.
Thank you.
Okay, any other questions? Hearing none, Vice Chair Feldman.
Okay, we're going to move to the next bill, which is Senator Benson. We've got Senate Bill 848. Senator Benson, I do see you there, and as you know,
I'm
all the
okay.
time you need to present your bill.
Thank you very much, Mr. Vice Chair. Esteemed members and Mr. Vice Chair of the Senate Finance Committee, Senate Bill 848 expands anti-retaliation provisions, Maryland wage and hour law, and prohibits an employer from taking adverse action as specified in the bill against an employee who takes specific actions related to state's wage payment and collection law. The bill also exempts specified independent contractors from the Maryland wage and hour law and alters the contents and timing of wage and pay periods, notices that an employer must provide to employees. With the recent enactment of earned sick leave and increasing the minimum wage, the General Assembly has made critical progress towards achieving fairness and safety within Maryland workplaces. Further action is required, however, to ensure that these bedrock protections do not exist only on paper and represent a reality for every worker in our state. Unfortunately, under current law, a minority of unscrupulous employers can and do deprive workers of their basic rights and undercut the success of their law-abiding competitors by sidestepping the law in several ways. And I want you all to know that before I put this bill in, I did have a conversation with a number of these employees. And it just troubles me because in a number of instances, These employees are fearful to even talk about it because they will fear if they complain, they will be terminated or their hours will be cut. And so here's what I want to say. When employers retaliate against employees who assert their right to be paid the minimum wage overtime and other other lawful earned wages, those bad actors get away without paying these wages at all. Employees, here it is right here. Employees are afraid of retaliation and often stay silent, even if it means working without sufficient pay, if they know that speaking up could cost them their job. Employers who purposefully misclassify their employees as independent contractors avoid paying required wages, unemployment insurance, and payroll taxes. Misclassification deprives employees of their earnings, the state of its revenues, and puts the majority of good employers at a competitive disadvantage. When employers fail to pay employees with proper pay stubs, it can mask the employer's violation of federal and state wage laws. Employees who receive pay stubs that state only a lump sum have no way of knowing whether they have been paid for all the hours they worked at the correct rate or whether or not proper taxes were withheld. Maryland must close these loopholes in the law to prevent low-road employers from skirting their obligations and to ensure the effectiveness of its minimum wage and earned sick leave guarantees. The Maryland Worker Protection Act closes these loopholes in the law by creating meaningful protections from retaliation for employees who make good faith inquiries or complaints about whether they are receiving their correct pay. Secondly, preventing employers from misclassifying workers as independent contractors when in reality, they are employees who are not in business for themselves. And the third, making paid stubs transparent so that they can obtain basic information about hours and wages necessary to allow employees to determine if they have received proper compensation. Together, these three protections ensure that Maryland's wage and leave laws are being properly followed and that Marylanders can work with dignity, not just in theory, but in practice. Therefore, I am asking that this wonderful committee would please give a favorable report on Senate Bill 848.
Well, thank you, Senator Benson. Any questions for the sponsor, Senator Joanne C. Benson? Okay, I do not see any. We're going to go next to your lead proponent, Jeff Guido. Jeff, you've been designated by Senator Benson to be the lead proponent. You get 5 minutes as a result.
All right, thank you, Mr. Vice Chair. Baltimore DC Building Trades support Senate Bill 848. People that are working on a project or working on at a job and they don't have representation, they're at the arbitrary mercy of their employers or their supervisors. You know, their schedules can be changed, hours can be cut. They may not get the overtime they felt they've earned or getting the proper wages for the hours they've worked, and they don't have any recourse. It takes a lot of courage to stand up or walk into the foreman's later, you're laid off. So you're not fired for creating a complaint. We support the bill and we urge the committee for a favorable report. Thank you.
Okay, thank you.
So that section should be amended to make it clear that business necessity or something similar to that is a defense or an exception to the changes in schedule that are adverse. And I agree with the fundamental intent, which is under normal circumstances, if an employer is making schedule changes and job assignment changes of the type that Mr. Guido just described, in order to punish an employee for standing up for his rights under the law, then that is something that should be prohibited. But you've got to deal with the edgy situation where the changes aren't made for any adverse intent. And I'd be happy to answer any questions.
Yeah, before we go to questions, I just want to make the point that this is jointly assigned to B&T, and I want to welcome Senator Elfreth. I think she's part of the hearing now officially, so representing the honor of B&T here. And there she is. So Senator Hershey, you've got the first question.
Thank you very much, Mr. Chair. And again, very similar bill to what we heard earlier. And I just wanted to say the same thing to Mr. McCall. I appreciate the very detailed letter that he provided to the committee. Certainly there are portions that are agreeable, portions that are affected based on the pandemic. And again, I urge my colleagues to take a look at that. It's very detailed and has some things as we move forward and debate the bill. I appreciate it, Chair.
Again, my thanks, Senator.
Any additional questions for Mr. McCall? Okay, seeing none, that concludes the bill hearing on Senate Bill 908. And Senator Augustine, I'm going to turn it to you for next bill or two that I'm going to do. Okay.
Was that 908 or 848?
I'm sorry. My bill, or oh, we have one more Benson bill. I apologize.
Yeah, 908.
Okay, I apologize there. That was, we probably should get Senator Elfreth back on the line. I think she jumped the gun.
Is she on this one?
That concludes the bill hearing on 848. We're now, I apologize, we're going to turn to Senate Bill 908. Jumped the gun on there. Senator Benson, I've jumped on you. You had Senate Bill 908 and I skipped over that.
Oh, you ready for me for 908?
Yes, so we concluded your prior bill and now we're going to Senate Bill 908.
Thank you.
You've got unlimited time to explain it.
Thank you so much. Thank you, Mr. Vice Chair, and esteemed members of the Senate Finance Committee. Senate Bill 908 would propose an amendment, if approved by the voters at the next general election, requires annual budget bills submitted by the governor to be accompanied by a statement showing the appropriations necessary to implement and fund each memorandum of understanding for the next ensuing fiscal year, whether reached through negotiations or binding arbitration, that is binding on the state and incorporates wages and terms and conditions of employment for executive department, higher education, and other state personnel. It is clear that Maryland's current bargaining system is just not working. As you are aware, in recent years, the governor has had difficulty reaching agreements with certain public sector unions. Most recently, Governor Hogan and AFSCME Council 3, Maryland's largest employee union, failed to reach an agreement on a new contract by the December 31st, 2020 deadline. Now, I want you all to know that I'm a union person, and I have to negotiate 4 contracts for the Teachers Association, Prince George's County. So this is very familiar with me, and this bill is extremely necessary because why? Here it is. Under present Maryland law, if there are unresolved collective bargaining disputes between the state and the bargaining unit, exclusive bargaining unit's exclusive representative, fact finders can be appointed to review, it's okay, and make non-binding recommendations based on proposals submitted by labor and management. But here it is. However, there is no requirement for these recommendations to be adopted. Now, what happens in this case? There is no process for mediation. There's no process for binding arbitration, and it's illegal in the great state of Maryland for public employees to strike. So this effectively puts the exclusive employee representative at the mercy of management to accept their proposed settlement. There is precedent for binding arbitration in Maryland. 8 counties currently impose binding arbitration for fire and EMS bargaining units through charter and code level legislation, in addition to certain state transit and public safety workers across the country. States such as Connecticut, Delaware, and Hawaii have reformed their labor laws to permit binding arbitration for non-public safety state employees. Therefore, I am asking that you give a favorable report to Senate Bill 908 so that we would create a process for dispute resolutions and binding arbitration, which in turn would create a more level playing field for employees and employers to bargain in good faith. Thank you very much, and I am prepared to answer any questions.
Okay, thank you, Senator Benson. Any questions for the sponsor? Okay, seeing none. Senator, your designated witness, lead proponents, David Wright. Mr. Wright, I see you there. You get 5 minutes because you've been designated the lead proponent.
Thank you, Vice Chairman. Again, my name is David Wright. I'm here to speak and urge a favorable report on Senate Bill 908 with amendments that the committee should have received recently that greatly elaborate on how the amendment would necessarily work and what needs to take place. As a matter of background, I am a partner at the law firm of Conn Smith & Collins and have the privilege of representing AFSCME Council 3 and also municipal employees for their unions, including firefighters and teachers, and also trade unions. What Senator Benson just described is truly a collective bargaining process that is incomplete and out of date. We need a complete process to reduce conflict among state negotiations. The complete process concludes necessarily with binding arbitration when necessary. That complete process ending in arbitration is quite well established, as Senator Benson noted. There are myriad Maryland counties and cities that have binding arbitration, and there are many other states that allow their state employees and local employees to end the process and get results through binding arbitration. To have binding arbitration that's funded requires a constitutional amendment. It's important, I believe, in speaking about this incomplete process to give a bit of history here. Collective bargaining is an incremental process in many ways, and it began in Maryland through collective bargaining rights through local employees and public safety unions. MTA employees, notably, as Senator Benson mentioned, have long been unionized and actually had access to arbitration through a different source since the 1970s. Of course, state employees were weighed into collective bargaining gradually. There was an executive order by Paris Glendening in 1996 that extended collective bargaining rights initially, and then they were developed statutorily in 1999 for executive branch employees and in 2001 for higher education employees. The process has been complete since the outset. In 1999, negotiations were simply set to end at some point before budget submission. In 2002, the law was changed to have a definite date of finality, but there has never been a process to resolve how the parties reach agreement when they are loggerheads, particularly over economics. There was, as Senator Benson noted, an improvement to the collective bargaining law in 2006 with fact-finding, but that is non-binding and therefore unsatisfactory for employees to be able to resolve and make their case about their proposals and their position. Over these last 20 years, as collective bargaining has been developed a bit in the state system, as Senator Benson noted, Anne Arundel County, Baltimore City, Baltimore County, Frederick, Howard, Montgomery, Prince George's, and the town of Ocean City have all adopted binding arbitration in one way or another, and it has been approved by the Court of Appeals as an appropriate way to resolve those disputes. Other states beyond what Senator Benson noted have arbitration, including Iowa, Illinois, Maine, Massachusetts, New Hampshire, New Jersey, New York, Pennsylvania, Alaska. It is the recognized best practice at this point. Why is that? Because it establishes an end to negotiation by resort to a neutral who resolves all the topics. And often simply having that process drives the parties towards agreement because of the efforts that are involved and because no one likes to lose. Binding arbitration brings rationality to negotiations. It brings evidence-based arguments to negotiation. It reduces passions and politics, and it allows for a neutral to choose one option over another, making those options well-supported, fair, and fiscally viable. So to wrap up, Mr. Vice Chair, the path here is clear. There needs to be a constitutional amendment because we are talking about the governor's budget powers under Article 3, Section 52. We need to require that the arbitrator's choice go into the budget and then also express the General Assembly's right to create enabling legislation to come later to round out the statutory scheme. And it would be the General Assembly's prerogative subsequent to enactment or change to the Constitution to create enabling legislation to determine who the neutral is, what standards a neutral would apply, and the timelines. Once that is done, we will have in Maryland for state employees a complete process. I thank you for your attention and again urge a favorable report.
Okay, thank you, Mr. Wright. Any questions for Mr. Wright? Okay, seeing none, we're going to go to the next witness, Dawn Hawkins. Mr. Hawkins, I see you there, and you've got 2.5 minutes.
Thank you very much, Vice Chair, Senators. Thank you for the opportunity to be with you today. And good afternoon. My name is Don Hawkins, and I'm the president of SB Local 3675. We represent the Maryland State Police civilian employees. And while we work side by side with our sworn colleagues, keeping Maryland safe, my members and coworkers, we feel the injustice on how our pay and benefits are determined based upon a very ineffective negotiation process. Here's just one example. We're currently losing police communication operators at an alarming rate. These dedicated men and women are our critical radio link between the public and the troopers. Yet while our colleagues' negotiations resulted in 15% in cost of living adjustments, 2-step increases, the best and final offer for our agreement was a contingent $500 bonus a year from now, and another very contingent 1% in 18 months. No step increases, and the state walked away from the table. To be clear, my testimony on this bill, however, is not about the final numbers. It's about the ineffective negotiation process. I have spent all of my pre-MSP pilot working life, when I was not in a Marine Corps uniform, on the opposite side of the bargaining table. I've worked companies out of Chapter 11, and I have built and sold 3 companies, including a defense contracting company. I'm quite familiar with the negotiating table, and I'm also very familiar with the purpose and value of a union within a large workforce. I have benefited from having a professional working relationship with the unions that represented my employees. With the understanding of what can be accomplished through mutual respect, I accepted my position as a union local president, and I have great respect for the MSP professionals I interact with in this capacity. I also recently served on ASME's bargaining team, and I was shocked and disappointed to discover that we do not have a professional working relationship between management and labor in the state of Maryland. The relationship that currently exists does not foster a climate for successful negotiations. It starts late, it gets dragged out, it's focused on petty issues, it leaves little time for serious discussion on hours, wages, terms and condition issues that directly impact employees and the services they provide. The current negotiation process has no sense of urgency for either party to reach compromises. The current system simply wastes the time of the people tasked to be a part of the effort because it quickly breaks down. So let me wrap this up by saying, please, after testimony in the House, there were a couple of well-meaning delegates that took the opportunity to share their perspectives regarding public sector unions. I have to tell you, I'm about the last person in this room that anyone would expect to be a union official. So I can understand their viewpoint, but with respect, I believe they should look at this a little differently. This issue is not about anyone's fundamental beliefs. It's about how you make the process work efficiently, effectively, and fairly for employers, employees, and the taxpayers. Management, labor, and Maryland taxpayers deserve a functional negotiations process that compels rational compromise and balance. That's why I'm here today in support of using binding arbitration as contained in Senate Bill 908 to bring balance to this process. Thank you for the time to talk to you, and I'd be happy to answer any questions if there are any.
Thank you for your testimony, Mr. Hawkins. Any questions for Mr. Hawkins? Okay, seeing none, we're going to go to the next witness, Deidre Williams. Ms. Williams, you're going to unmute yourself. There you go.
Thank you. Thank you.
You've got two and a half minutes, Ms. Williams.
Okay, thank you. Good evening, committee members. My name is Deidre Williams, and I work with the Department of Juvenile Services as a community detention officer. I am also a proud member of AFSCME Local 3167. I've been working with the state of Maryland for going on 18 years. When I first started working with the Department of Juvenile Services, one of the things I was told was that the state had steps within wage classes, and it was something I truly look forward to receiving every year. Each year, I've received 3 personal performance evaluations, and I've never scored less than outstanding, but yet and still, sometimes I do not get my increase or my step each year. Steps were supposed to be salary increases provided annually for satisfactory performance on the job, as well as recognition that experience helped the state work for Marylanders. In my 18 years of working for the state, I've only received 9 step increases, which is far from what I should have actually gotten. This is happening to others who are represented by AFSCME, like myself, yet there are other employees throughout the state of Maryland that receive their steps every year and they get their increases. Why is that? Is it not important to give out raises to those workers who this pandemic have not only proven to be valuable, but also very valuable? I love my job and I do it very well. However, I feel like the state of Maryland does not return the love back to their employees in the correct way. There should be more fairness and equity applied, in my opinion, and it's not happening now. It is my hope that this legislation that I sit before today will help to bring binding arbitration to collective bargaining, will fix the wrongs because it's the right time to do the right thing. Having a process to promote compromise and agreements is needed, and I feel it is the right thing to do. Your involvement today will help pass this bill in a huge way, and it will help Marylanders feel appreciated beyond a thank you or receiving a personal performance evaluation that comes with little to no consistent incentives. I thank you all for taking this opportunity to allow me to speak today, and I look forward to something changing. Thank you again.
Okay, thank you, Ms. Williams, for your testimony. Any questions for the witness? Okay, I don't see any. We're going to go to the final witness on this bill, Lance Kilpatrick. Lance, you've got 2.5 minutes. You're the last witness on this bill.
Thank you, Mr. Vice Chair. Members of the Finance Committee, good afternoon. For the record, my name is Lance Kilpatrick with AFSCME Council 3. May of this year will mark the 25th anniversary of collective bargaining for Maryland state employees. In the years since Governor Paris Glendenning's executive order, Maryland has continued to improve its collective bargaining practices to have in place processes that are fair, balanced, efficient, and conclusive. This proposal adheres to that path. The concept behind collective bargaining is to establish a forum for management and labor to periodically sit down at the table to formally discuss issues including equitable compensation, leave and benefits, processes for employees' input and participation, and myriad other terms and conditions of employment. The linchpin of collective bargaining is a mutual understanding and respect for the process itself, where finding common ground through deliberation and compromise is acknowledged by all parties. Unfortunately, as Mr. Wright and Mr. Hawkins have stated, compromise is not always the case. And under present Maryland law, an employer within state collective bargaining can effectively refuse to move from their initial positions and thus create a stalemate that has no resolution. Without incentive to work toward agreement through compromise, there is no concern for the consequences of inaction. And as Ms. Williams testified, there are real life consequences that are happening because of our existing system. Senate Bill 908 is a strong and positive step toward enhancing fairness, balance, efficiency, and resolution. It follows a model that is well established in other states and among Maryland counties. We want to thank Senator Benson for her leadership on this issue and her ongoing support of all workers in Maryland. We thank you and we urge a favorable report from the committee.
Okay, thank you, Mr. Kilpatrick, for your testimony. Any questions for the witness? Okay, seeing none, that concludes the bill hearing on Senate Bill 908. My apologies to Senator Elfreth. We got the two Benson bills a little mixed up there, but it's all good. Thanks for joining us. Okay, now, Senator Augustine, I'm going to turn it to you. This time, I think it counts.
All right, fantastic. Thank you, Vice Chair Feldman. We're going to now hear from Vice Chair Feldman on Senate Bill 728. You have all the time you need, sir.
Okay, thank you. Thank you, Senator. So I don't know, I think Senator Hayes is on the line. Let me, the reason I make that point was this bill in part, and this is a cross-file with Delegate Pena-Melnick, I would say maybe the idea for this bill sort of started with Senator Hayes' bill from a year ago, Senate Bill 943, which dealt with workplace safety plans in the healthcare space. If you remember, a bill that passed out of this committee unanimously. And you know, when you go past that sort of more narrow bill, we've got states that have similar laws to what's presented here in Senate Bill 728 outside of healthcare. You've got 11 states that mandate health and safety committees for larger businesses. We've got 14 states that mandate, you know, injury. Well, and those states are places like West Virginia, Alabama, North Carolina, Tennessee, not exactly like deep blue America. And we've got 11 states that require illness prevention programs. Those states include Mississippi, Montana, Utah. And so, but outside of the bill that we passed last year from Senator Hayes, we don't have laws on the books or requirements or provisions for workplace safety like those states or outside of healthcare. And so workplace safety is a big issue. When you look at Maryland's data from 2017 to 2019, pre-COVID, what you'll find is there were over 193,000 workplace injuries and illnesses that were reported in Maryland. Of these, of that 193,000, 108,000 were considered serious enough that the worker had to actually spend several days away from the job. And in 2018-19, there was actually a spike in worksite fatalities. And so borrowing from, you know, the ideas of Senate Bill 943 and broadening it out, what Bill 728 is intended to address is this issue of workplace safety and the presence or requirement of workplace safety plans. And so the bill as introduced was broad, prescriptive, and the bill's been substantially amended. Let me just make that point to make the bill far less prescriptive And that was after some conversations, I think, with ABC and our Department of Labor. It also addresses some privacy concerns that were raised, and it, I think, better aligns the reporting mechanisms with what's in place already, and also pushes back the effective date. So that's all in these amendments that are in the possession of the committee. So what the bill basically does, it requires employers with 20 or more employees. That's amended from, as drafted, 10 employees or more. It's now 20 with the amendments, to establish health and safety committees composed of an equal number of employees who work for management, folks who work for management, and employees who don't work for management, equally between employees and employers, a committee. Many employers already do this. I mean, no doubt about it, they do injury and prevention programs and have some form of a health and safety committee. And for them, this bill is essentially codifying what already exists. But for those who don't have those things in place, I think with these amendments, I think this makes some sense. I don't think they're as onerous as the bill as originally drafted and introduced called for, but I think they have the potential to have a significant impact on workplace safety. So again, it requires all employers in that 20 employee plus category to establish, implement, and maintain a written injury and illness prevention program. It requires MOSH to report to the General Assembly annually on the rates of injuries and illnesses based on the latest submission to the Bureau of Labor Statistics, and requires MOSH to establish standards specific to the hazards that are causing above average rates of work-related injury and illness in Maryland. So just two quick things. So what will this Health and Safety Committee be required to do? So under the amended version of the bill, they have to meet regularly, not less than quarterly. Again, different than the bill that was originally introduced. All that's required of this committee is they submit recommendations to and evaluate safety suggestions from employees to prevent injuries and illnesses. We want our frontline workers to have input, verify the abatement actions taken by the employer on any health and safety citations the employer received by MOSH, establish procedures for employees to report concerns without any fear of retaliation or reprisal, maintain records of committee activities for at least 3 years, and finally work with management to develop and implement an injury and illness prevention program, which is required in the bill. That's all the committee is required to do under the amended version of the bill. Now, I should note that OSHA, the federal folks, already require employers with 10 or more employees to report recordable injuries and illnesses. And OSHA defines a recordable injury and illness as any incident that requires more than first aid. So there already, for 10 workers or more, is a requirement under federal law. So anyway, you have the committee. And then finally, what is this injury and illness prevention program that I described and is required here entail? So all it requires is a written plan that specifies what the employer is doing to find hazards. And we've amended the definition of hazard, tightened that up in the amendments. Fix hazard, so again, specifies what the employer is doing to find hazards, fix hazards, train employees, and maintain the program. And I think what's envisioned here is basically a template form that can be put together by the Department of Labor, so it wouldn't be that hard. And then finally, the plan should be accessible upon request to labor commissioners and to employees. And that's all the bill does in its amended form. And so with that, Mr. Chair and members of the committee, I'd ask for a favorable on 728 as amended. And I'll take any questions.
Thank you, Vice Chair Feldman. Are there any questions from the committee for the sponsor? Okay, seeing none, we'll move on to the first witness who will be given 5 minutes, Denise Gilmore.
Good afternoon, Mr. Chair and members of the committee. My name is Denise Gilmore, and I'm a field director with AFSCME Council 3. I first want to start with thanking Senator Feldman for introducing this important bill for our members and all workers across the state, and for his wonderful explanation of what the bill does. I won't rehash that too much in my testimony, and I'm certainly happy to take questions. But I do want to, address some of the opposition points you may have heard as a result of this legislation. But I'll begin by saying that, this legislation, like all legislation, really forces us to ask the question of, is there enough wrong with the status quo to necessitate a legislative change? Well, here's the status quo. In Maryland, between 2017 and 2019, over 193,000 workplace injuries and illnesses were reported. Of those, 108,000 were considered serious enough that the worker had to spend days away from their job. Nationally, businesses spend over $60 billion a year on disabling worker injuries. This is particularly hard for smaller businesses who can be out of hundreds of thousands of dollars for a single worker injury in their work site. We've worked with the sponsor, as he mentioned, to draft amendments that address many of the concerns the opposition has raised with the bill, including increasing the committee requirement only to those employers who have 20 or more employees and making it less prescriptive. But we are aware that there's still some opposition. Now, some of this opposition is based on the notion that we're already doing everything that can be done to prevent work-related injuries. But I do have to ask, if we were doing all we could already do, and OSHA and MOSH already had all the necessary standards in place, why would these injury and illness numbers in Maryland still be so consistent from year to year? As amended, SB 728 only requires 3 things: for employers with 20 or more employees to establish health and safety committees to foster that collaborative culture of health and safety at the work site, that these committees maintain meeting minutes, and that Maryland employers have a written and injury and illness prevention program, which honestly, as the senator mentioned, will probably be a generic form that gets created. These requirements aren't that onerous. The science proves that these small measures can go a long way in making work sites safer. Businesses often oppose standards by saying they're one size fits all. Occupational safety and health standards should protect all people in all situations. Let's take the hazard communication standards that regulate all hazard materials coming into the workplace. That standard doesn't differentiate between what the chemical is, only that it's toxic. Or standards that require exit signs be placed for fire safety or handrails for stairs. These are all one-size-fits-all standards. I'm sure we can all agree have benefits for safety and minimal imposition on the employer. Injury and illness prevention programs that include health and safety committees are along the same vein. SB 728 takes what good employers are already doing and expands it into smart statewide policy to help us lower the number of incidents that lead to Maryland workers getting hurt or ill at work yearly. At AFSCME Council 3, we know firsthand that this method can work. In 2011, we negotiated a workplace violence prevention program with the Department of Health for our state hospitals. It included the establishment of health and safety committees at each hospital that worked on identifying risks and put recommendations in place to prevent assaults on staff. Between 2012 and 2015, we saw nearly a 50% reduction on patient on staff assaults at some of the facilities and an 18% reduction in assaults that lead to serious injury. We're pushing to codify this into language because unfortunately, we haven't had much success getting this current administration to follow that negotiated policy. Finally, I'd just like to address the fiscal note very quickly. Last year, a heat stress standard bill was passed in which the fiscal note was around $184,000. We don't really see why this standard would cost, over $500,000 then to implement. It's also worth noting that the fiscal note didn't mention that currently the federal government matches everything MOSH puts in. We certainly welcome the discussion about why MOSH only has capacity to do 60 inspections a year, but for all standards, not just this one. We believe SB 728 can be enforced with current capacity to the same extent other standards are being enforced. Please provide a favorable report on SB 728. We can and must do more to prevent workplace injuries and illnesses. Thank you very much.
Thank you for your testimony. Members of the committee, are there any questions for this witness? Okay, seeing none, we will move on to the next witness who has 2.5 minutes, Scott Schneider.
Okay, thank you very much. Good afternoon, Vice Chair Feldman, Senator Augustine, and all the members of the committee. My name is Scott Schneider. I'm a certified industrial hygienist and a fellow member of the American Industrial Hygiene Association. I've been working as a hygienist for over 40 years, most of it focused on construction safety. Been a 35-year resident of District 20, and I'm testifying today on behalf of the National Council for Occupational Safety and Health in support of the bill. Illness and injury prevention programs work. I've appended to my testimony a report issued in 2012 by federal OSHA that recounts the research supporting this statement. Many states already require them. California has required them for 30 years. Why do they require them? Because they save lives. States with illness and injury prevention programs have 31% fewer fatalities than other states. OSHA estimated these programs will also reduce injuries and illnesses by 15 to 35%, saving $9 to $35 billion in workers' comp payments alone if implemented nationwide. All the companies in OSHA's voluntary protection program, which is available only to the nation's best companies, have such programs. The bottom line is you can't really address illnesses and injuries in your workplace without a plan. You have to have outline a systematic approach to prevention. Management commitment and employee involvement are the most important elements of such a plan, which is where this Joint Health and Safety Committee language comes in. One note, for required training, I would suggest training be done in the languages spoken by most workers in that workplace, and that's in the amended version of the bill. Employees are the ones who know the workplace best and are usually the ones to recognize and identify hazards at work first. They also have the best ideas to fix them. Their active participation through a joint safety and health committee helps ensure the success of the entire program. Not all safety and health committees are successful. Their success depends on choosing representatives that are not afraid to speak up, having adequate resources and time, effective training of committee members, and giving the committees the authority and budget to act. But having a committee allows the possibility of active involvement of workers and active surveillance of the workplace to identify problems early and allow them to be corrected before an injury occurs. Without such committees, it's difficult to solicit and encourage worker input and participation, which is so essential to workplace prevention efforts. Committee members should get trained so that they can be most effective in their roles. For these reasons, I encourage you to give a favorable report to this bill. I'm happy to answer any questions. Thank you very much.
Thank you, Mr. Schneider. Any questions for this witness? Okay, seeing no questions for this witness, we'll move to the next witness, Donna Edwards, 2.5 minutes.
Good afternoon. I want to thank the committee. It's always good to see the Finance Committee. Vice Chair Feldman did an excellent job at explaining this bill and now all of the amendments. I also want to thank Senator Hayes for bringing it up last year and the work that the committee has done on it. I'm not going to repeat everything that's been said. You've got written testimony. I do want to go to that. Vice President Feldman did mention, I mean, we have states like West Virginia, Alabama, et cetera, that have this law in place. Alabama's is so simple that any employer of 5 or more, if the employees ask for a health and safety committee, they get it. So, you know, we don't want to make it any more difficult than people think it is. But in preparing for this bill, I did some research all around the country, and from Washington and Oregon, all the way down to Florida, all the way up to Maine, all of the experts on workers' compensation agree that the major tool to prevent injuries and illnesses is a labor management, health and safety, injury and illness, whatever you want to call it, committee. And so, I mean, workers' comps are saying this will actually reduce your citations and it will prevent injuries and illness. Also, according to the Department of Labor, companies that have a workplace safety and health committee, they actually see an improvement in their business's profitability. So by doing a joint labor management, health and safety committee, you not only have the commitment of management, which I believe most businesses certainly don't want to have injury and illnesses, but you have a culture being built within that business that everyone is responsible for safety and health. And so it buys it in. And I know that, maybe part of the loss of our manufacturing industries that we've had, maybe that has caused us not to concentrate so much on joint labor management. And I'm not talking within organized labor, I'm talking anywhere in our businesses, to have these committees that actually, work together to make life go smoother at the work site and be healthier and safe. Because I know it was always a big deal in any plant, anywhere, that they would actually have big signs up, and sometimes even along the road, how many days and years they had gone without an injury. And I think we want to get back to that culture. And for any of you, like I have the big poster from DOL on all of workers' rights. And in that, there's a line that you can keep improving on and saying how many days you've gone without an illness or an injury. So I just think it's an important part, and I would really appreciate a favorable response and to Senate Bill 728 for all workers and all businesses. Thank you.
Thank you for your testimony. Members of the committee, any questions for this witness? Okay, seeing none, we'll move on to favorable with amendments. Champ McCullough, 2.5 minutes.
Thank you, Senator, and thank you, members of the committee. I have not had the privilege of seeing the amendments that the Senate sponsor addressed during his remarks. However, we work very closely with Delegate Pena-Melnick. When I say we, I mean AGC and ABC, the two big construction trade associations, and agreed upon a set of amendments that we thought would serve the employees well, would serve industry well. And if those are the amendments that Senator Feldman is speaking to, then I think we're perfectly content. If they're not, then we'll have to reserve endorsement. But assuming they are, we would recommend the bill be given a favorable report. There's a couple of minor issues that the committee should just be aware of. And one of them is that in deciding on the composition of the committee, it's important that senior management, not just line management, but that senior management, line management, and employees constitute the committee. And secondly, it's important that with respect to the number of employee members, that they be at least equal to the number of management members. And we say at least because in many cases, you want more employees. As members of the committee, you have different crafts, you have different work sites. And so it's very typical, at least in the construction industry, for safety committee to have more non-management employees than it does management employees. And so the equal number would actually be a detriment and not a benefit to employees. Lastly, we were very concerned about provisions in the bill as introduced that would give the minutes of the committees to the general public. Fortunately, we were able to reach agreement with the House sponsor, and I believe with the support of maybe a little unwilling, but with the support of Ms. Gilmore and Mr. Schneider as well, that these were appropriate things to be taken out of the bill. So again, assuming the amendments are those which the delegate sponsor of the House bill agreed to, we would certainly support Senator Feldman's bill with those amendments.
Thank you. Yeah.
Yeah,
Vice Chair.
Just to that point, yeah, these amendments conform verbatim to Delegate Pena-Melnick's amendments submitted in economic matters.
And then I think the construction industry is a happy camper.
Okay, any questions for Mr. McCullough? All right, seeing none, we will then move on to unfavorable. Dan Dougherty, 2.5 minutes.
Thank you, Senator Augustine, Vice Chairman Feldman, and members of the committee. I'm Dan Doherty here on behalf of the Maryland State Dental Association, respectfully opposing the bill. And I have to echo what Mr. McCall said. I have not seen the amendments. I would think they may diminish some of my objections, but I have a feeling that my concerns as to the appropriateness for this kind of bill to a dental practice may still exist. Dental practices are regulated with respect to patient and employee safety, not only by MOSHA, but by the Department of the Environment, the Department of Health, the Board of Dental Examiners. They have to follow all the CDC requirements. And I'm not aware of anything but maybe some de minimis instances of where employees have been injured or acquired illnesses in a dental practice. In fact, during this pandemic, there have only been a handful of cases where dental employees have contracted COVID, and the tracing has indicated none of them had come from the practice setting. So we really don't think this applies very well to dentistry. We're more concerned with following CDC guidelines, Department of the Environment radiation protections. Our employees have to wear badges so the exposure of radiation is detected, and we make reports on those already. The second thing is the employment numbers. And while 20 is better than 10, it's very common, if not more or less generally true in most dental practices, that many of their employees are part-time. Dental hygienists, dental assistants often only want to work part-time because they're raising families. In many cases, the practice that cannot support them 40 hours a week, so they split their time among 2 or more practices. And that's even true with young associates. Young associates come out of dental school, they have a lot of debt, but few practices can hire them for 40 hours a week. So they work between more than one practice. How do we count the employees? Are we talking about every part-time employee counts as one? And if so, that employee who is involved in our practice and it deals with the safety committee also has to deal with the same thing in another practice. And I don't think this in any way enhances or improves the safety of the employees in a dental office. We really do feel that the dental practices and possibly other medical practices should be excluded from the bill. This is not a typical industrial commercial business. And with that, I would urge you to consider our concerns. Thank you.
Okay, thank you, Mr. Doherty. Are there any questions for this witness or the sponsor on this bill? Okay, that will conclude Senate Bill, the hearing for Senate Bill 728. Vice Chair Feldman, we're going to move now to Senate Bill 727, and you have time to explain your bill.
Sure, thank you. Now, I'm going to be brief. Let me just say at the outset that when we talk about passing legislation this session for worker protections during public health emergencies, which is what we are now, I am going to say that I do believe that Senator Augustine, your bill, Senate Bill 486, and Chair Davis's bill, I think that has been, I think the vehicle, you know, I'm on the work group with Senator Hershey as we continue to work on that bill, and I just want to make that point. And so this bill dealing with leave during a public health emergency, there is overlap here. But as we continue to discuss this topic that we've been discussing this session about essential worker protections, I think it's important to throw into the mix here the issue of the gaps exposed in our leave laws in that rare occurrence of a public health emergency. And specifically what we're talking about this past year has been if you are required by the CDC or public health officials to quarantine for 14 days and you don't have enough leave to back that up, then what do you do in that, again, rare occurrence? It is a problem, and the workers in that scenario are forced to pick between a paycheck or going in and spreading illness over maybe requirements that they stay at home. And I think that is a problem. So my hope in part here is to at least think about this bill in the context of Senate Bill 486. It's possible that maybe some portions of this might make its way into that bill, and I'm just going to put that out there. There's a lot of opposition to this bill, similar to where there was for Senate Bill 486. I will add, though, this difference when we're talking about leave policies. I think this is an area where we could get pretty creative. So, for example, when I look at the American Rescue Plan that just passed the United States Congress at the federal level, they actually have tax credits in that legislation for COVID-related leave to employees. And so I think, the Congress was, I think, thinking about ways to address this issue in the rare public health emergency context that really mitigates the burden on employers. And I think that, and we have other states that have passed bills like this, Colorado, New York, New Jersey. And I think all these states are looking for maybe some creative ways to, again, in that rare case of a public health emergency and these scenarios about quarantines, lack of leave, and you want to protect the public. And that's what this bill is. So this bill focuses on the current law and gaps embodied in our Healthy Working Families Act, again, in the context of public health emergency, to avoid that scenario where the worker is forced to choose between spreading illness and getting a paycheck. And so I'm going to just stop there. I think this is important to throw into the mix as we move forward in the last few weeks. And I think I'll just turn it over at this point to the proponents that have signed up to testify. I think starting with Tyra Robinson as the lead proponent witness that I've designated.
Sounds good.
Bill does.
Sounds good. Any questions for the sponsor? Okay. So hearing no immediate questions for the sponsor, we will go to Tyra Robinson as the lead proponent. You have 5 minutes.
Thank you. Good afternoon, Chair, Vice Chair Feldman, and members of the committee. Thank you so much for the opportunity to testify today, and thank you, Vice Chair Feldman, for that introduction. My name is Tyra Robinson, and I'm an attorney with the Public Justice Center at the Workplace Justice Project. At the Workplace Justice Project, we work to ensure our state's low-wage workers receive full and fair payment for their labor, as well as other basic protections on the job. PJC was a founding member of the Working Matters Coalition, which helped pass the Healthy Working Families Act years ago, which established the right for workers to earn 5 days of sick leave per year. I'm here this afternoon to urge your support on SB 727 to address COVID-19 and future public health emergencies. There were 658 new confirmed cases of COVID-19 in Maryland just yesterday. Today, the total COVID numbers in Maryland are almost 400,000 Marylanders who tested positive and almost 8,000 Marylanders whose lives were lost. Positivity rates have gone up in the last 5 days, and even with access to the vaccine, and particularly considering the lopsided allocations of the vaccine and access to it, the urgency of action continues. The basics of this bill are to expand Maryland's sick leave law generally to cover agricultural workers, temporary workers, and on-call health professionals, because these excluded groups from the law get sick too. It also alters the family definition to bring it up to date with national shifts and more inclusive and modern family structures. And finally, it establishes additional amounts of sick time adequate to respond to a public health emergency. You're going to hear opposition with respect to a couple of issues today, and that includes employer burden and cost, which Senator Feldman addressed a little bit already, as possible creative options to address that, and that these are unnecessary changes to the law. So let me clarify those issues at the outset. First, we acknowledge that concerns about employer burden and costs are reasonable, and we also recognize that we must do something about the impacts to workers. Workers in a typical non-COVID year usually need to take off work due to illness at least once. During a public health emergency, under this bill where an additional 14 paid sick days would be available, every worker won't necessarily need to take that entire period. And in that circumstance, an employer would only have to pay for the days that they do need to be off, whether it be to get tested, wait for test results, take care of a family member with symptoms, or get vaccinated as enumerated in the bill. Let me be clear, this is not an either or situation, it's a both and. Businesses have a lot of support from federal and local government, and that's why we've been advocating to budget decision makers to discuss affordability options. We're happy to continue engaging in solutions so businesses can afford this and workers can be protected. For example, we could set up a plan similar to the federal plan for businesses who provide sick leave to be reimbursed through the rainy day fund, state grant programs, or the tax credit that Senator Feldman mentioned. Second, these amendments are reasonable and are necessary. We know many employers are doing their best to be flexible with workers during the pandemic. We also know that other employers are putting their employees, patrons, and communities at further risk of danger when they make their employees come in sick or will not allow them to use their earned and accrued sick and safe leave time to go get tested. Businesses who are opposed to this bill have employees who continue to be exposed to COVID-19. And as restrictions decrease, the risk of exposure will increase. There are gaps in coverage of workers who have access to sick leave, and these gaps are occupationally based as our current sick leave law is. But any gaps further expose Maryland to outbreaks and weakens the health of the state overall. At the PJC, we've heard a variety of worker experiences that caused us to want to bring forward this bill. To summarize just a few, in District 3A, a worker providing home care support tested positive for COVID and only had 12 hours of available leave under the Healthy Working Families Act. So she had less than 2 work days to quarantine and recover from COVID before she lost job protection. In District 42B, a teacher for incarcerated youth was hospitalized with COVID-19, and it has taken them 3 months to recover, and they're still not breathing the same due to lung damage. In District 32, a bus driver still needs to go to the doctor for follow-up appointments due to lasting lung issues from COVID-19. In their workplace, the health department was sent to inspect, but managers still walk around the indoor facility without masks on. And in District 46, a warehouse worker rarely has sick time requests approved by their employer. I'll close with this. This bill fills a critical gap in public health and workplace protections by recognizing that everyone gets sick and deserves time to recover without jeopardizing their economic stability and community health. 5 days is enough time to recover from a common cold, but not an infectious disease. COVID-19 is still an ongoing issue, and people are counting on legislatures across the country to step in and do something. 1 year after the state emergency was declared by Governor Hogan, and still very much in the pandemic, Maryland has an opportunity and obligation to do something meaningful for public health in the public health emergency. Thank you.
Thank you for your testimony. Do we have any questions for this witness? Okay, seeing no questions for this witness, we'll move to the next witness, who is Corey Johnson. Corey Johnson, you have 2.5 minutes.
Good afternoon, Mr. Chair, Vice Chair Feldman, and members of the Senate Finance Committee. For the record, my name is Corey Johnson, and I'm an attorney and the Senior Policy Research Analyst at the Job Opportunities Task Force, where our mission is to advance low-wage workers to employment opportunities and eliminating barriers to employment. We strongly support Senate Bill 727 as a means of ensuring that hardworking Marylanders can continue to access our paid sick and safe leave law that extends to reflect a public health emergency without having to risk their job, paycheck, or financial security. The COVID-19 pandemic has had a crushing effect on the lives of many Marylanders. The Maryland Department of Health confirmed that there have been over 400,000 confirmed cases and over 8,000 deaths related to COVID-19. What has been even more discouraging is that our population's most vulnerable have been impacted the most, to include minority communities and women. First, poor Black communities have borne a brunt of the devastating outcomes of the virus's fatal impact, as the virus has been particularly unforgiving for marginalized communities. Black residents make up 30% of Maryland's population, yet they make up 41% of COVID-related deaths. The pandemic has also resulted in every corner of inequality being exposed. This holds true as it pertains to the impact of the virus has had on vulnerable populations in the workforce. According to the American Progress Organization, nearly 1.1 million people were forced to drop out of the labor force due to the pandemic. 865,000 of those individuals were women, compared to 216,000 being men. Now more than ever, our goal should be to protect the financial security of Marylanders while also balancing the best interests of business owners. Senate Bill 727 would expand coverage under the current paid sick days law by 1, establishing public health emergency leave, which Tyra already covered. 2, extending the applicability to industry workers that are now considered essential workers. And 3, allowing all workers to have access to using 14 paid sick days under a declared public health emergency. Moreover, this legislation would protect small businesses by allowing sick employees access to sick leave. This promotes safety in the workplace and shields employers from liability of facilitating unsafe working environments. This would also allow employers the ability to protect their employees, their staff, and consumers. The World Health Organization scientists predict that we will see another pandemic within the next 60 years. The pandemic has exposed a vulnerability for our state, and we think it's time to fill that gap. For the reasons above, we urge a favorable report of Senate Bill 727.
Thank you, Corey Johnson. Any questions for this witness? Okay, seeing no questions for the witness, we'll move to the next witness, who is Joseph Carlson. 2.5 minutes.
Thank you. My name is Joe Carlson. I operate a bookstore with my wife in District 40. Altogether, we have 4 employees, including ourselves, and we understand how difficult it can be to be unemployed. Back in October, our employees came into contact, actually I came into contact with a person who had tested positive for COVID. So we immediately closed our business for a week, paid our employees to stay home, get COVID tested, and wait for multiple results. Although federal law at the time accounted for this situation, it was not required under Maryland law. We thought the right thing to do was to give them time off to get tested, and myself tested to make sure our health was protected. This wasn't a huge hit on our business, and we were only in our 2nd year of business. Looking at this legislation, to implement a requirement for businesses to allow employees up to 14 days of sick leave during a public health emergency, and recognizing that every business does not have the same resources. A tax credit from available state or federal funds could help smaller and lesser resource businesses like ourselves to apportion sick leave to their employees, just as we did. This is achievable, and we are proof of it being done. I urge a favorable report on SB 727 because I have the philosophy of taking care of others and think it's particularly important for employees to have access to sick leave in a public health emergency. Thank you very much.
Thank you, Joe Carlson. Are there any questions for this witness? Okay, seeing none, we'll move next to Carla Gilbride. Carla Gilbride, you have 2.5 minutes.
Thank you to the committee and to Vice Chair Feldman for the opportunity to speak today and for SB 727. My name is Carla Gilbride. I'm an attorney with Public Justice, and I'm testifying here today on behalf of the Marylanders for Food and Farm Worker Protection, which is a coalition of civil rights and environmental groups who came together during the COVID-19 pandemic to advocate for workers in the agricultural sector who continue to work every day in dangerous jobs in order to put food on all of our tables. The brunt that workers in the meatpacking, farming, and seafood processing industries have borne in terms of COVID infections and deaths from this pandemic is difficult to take the full measure of, but they have borne a disproportionate toll. According to the Food Environmental Reporting Network, there have been at least 88,359 workers in these industries who have tested positive at outbreaks in a number of facilities, including several outbreaks that have occurred at seafood and poultry processing plants here in Maryland, and 376 of those workers have died. Because those figures only account for people whose occupation was known, it certainly undercounts the toll that this pandemic has taken on workers in these industries. And it's no surprise why outbreaks have been particularly common in meatpacking and other agricultural sectors. Workers in meat processing plants spend hours a day in close proximity to their coworkers on fast-moving production lines. Many migrant farm workers are housed by their employers and transported to the work sites in congregate vans, also in close proximity to other workers. And these conditions are prime candidates for contracting and spreading contagious disease. Many employers in the agricultural sector have points-based attendance policies that penalize workers for missing a shift, and those penalties are up to and including termination. Those attendance policies incentivize workers to continue coming to work even when they have symptoms of a contagious disease. And those outbreaks, even if they begin in the workplace, are certainly not contained there, but spread to surrounding communities and place all Marylanders at risk. Even though we are hopefully reaching the light at the end of the tunnel with respect to COVID-19, as other witnesses have testified, rates of infection continue to be high within Maryland, and the rate of vaccination continues to be slow and to have racially disparate impacts. While 25% of—
Albright, if you can get to the conclusion, you've extended beyond the time.
Yes, I'm almost finished. While 25% of white Marylanders have received at least one dose of the vaccine, only 8% of Latinx Marylanders and 14% of Black Marylanders have received one dose of the vaccine. And Black and Latinx workers are disproportionately represented among food and farm workers. So for all of those reasons, this population particularly needs the protections of the bill, but are currently excluded because of the agricultural worker exemption, which applies to thousands of workers in agricultural operations of all sizes, not just to small family farms. So for all of these reasons, we strongly encourage a favorable report of Senate Bill 727.
Okay, thank you for your testimony. Are there any questions for this witness? Okay, seeing none, we will now move to the unfavorables. The first one will be Kaylee Locklear. You have 2.5 minutes.
Good afternoon, Mr. Chair, honorable members of the committee. Kaylee Locklear, for the record, here on behalf of the Maryland Retailers Association in respectful opposition to this legislation. As we have discussed before, the majority of businesses truly are good actors. They care about their employees and have already offered additional paid leave when they could. But as you are aware, even the federal government realized that they had to offer tax credits to businesses to help with employees that had to use leave. And the reason they did that is because they knew that businesses could not shoulder the cost burden. Additionally, this bill goes beyond current CDC guidance or recommendations for leave seen anywhere for COVID without any verification. And it contemplates the exact same disease behavior in a person for a future health crisis, which is, as we've discussed, impossible to predict. There are numerous issues in the bill, and Senator Augustine, we've been working on the emergency definition, for instance, but there are also reasons for usage for paid leave that we just can't support in this bill. As I stated, they do not seem to be tied to the current recommendations for isolating or quarantining or suspected exposure, or even follow precedents for whom leave can be taken that's either set by FMLA or other areas of the Maryland Code. Leave in the bill, for instance, and I quote, can be taken for someone whose close association with the employee is the equivalent of a family relationship. And then there's just this very broad definition of a communicable disease that's problematic. Being limited on time, I want to adopt the comments of my colleagues, and as many of you are aware, the legislature did pass a sick leave policy years ago. I just want to point out that on page 8, this leave is added on top of that policy. This bill does not contemplate any federal leave provided as well, and it layers on top of unpaid FMLA. So for these reasons and much more, we're in strong opposition to this legislation. Thank you.
Thank you for your testimony. Are there any questions for this witness? Okay, seeing no questions for this witness, we'll move to the next witness, which is Mike O'Halloran. You have 2.5 minutes.
Righty. Thank you so much, Senator Augustine, members of the Senate Finance Committee. For the record, my name is Mike O'Halloran, here on behalf of NFIB Maryland, in opposition to Senate Bill 727, legislation creating a brand new section of paid leave under the state's sick and safe leave law. It also reverses, as you just heard, some of the hard-fought compromises made during debate over the Healthy Working Families Act a few years ago. The committee has heard from many Marylanders today and in other hearings this session about the financial hardships workers have faced and many are still facing because of the COVID-19 pandemic.
You have also heard from small business owners, how they share these very same stories. Just as your constituents struggle to pay bills, small business owners are struggling to pay bills at their shops, restaurants, and stores, in addition to their own homes. On the issue of reversals to compromise laid out in the state's sick and safe leave law, you just heard how SB 727 expands the definition of a family member to include virtually anyone an employee considers family. A few pages later, 1306A1 ignores a determination of paid versus unpaid leave based on an employer's size for the purpose of this newly constructed leave. This committee decided nearly 3 years ago to acknowledge that our smallest employers, those with fewer than 15 employees, should not have to provide paid sick and safe leave. There was an understanding then that small business owners work with their employees to come up with other arrangements equally beneficial to both parties when an employee needs to be away from work. This section ignores that determination by forcing all employers, regardless of size, into providing almost 3 work weeks of paid leave to their full-time employees. For part-time employees and those whose hours vary week to week, the bill mandates an amount of leave that is nearly impossible to determine based on the language in 1306. In fact, the fiscal note just left it at, quote, a specified manner, unquote. Taken together, paragraphs C, D, and F under 1306 would entitle an employee experiencing symptoms that are oftentimes associated with the common cold to paid leave without having to provide any documentation to their employer. It's particularly concerning because an employer can require documentation for an employee's absence under the other leave allowed in the Healthy Working Families Act. Finally, 1306C7, coupled with Section 3, not only sets up a logistical nightmare for small business owners, but a financial one as well. Together, this language states employees are guaranteed paid leave from a small business owner, even though that business was forced to shut down by an executive order. I simply don't know how small business owners who could have been shut down for the better part of the summer, unable to earn money for his or her business, will somehow be in a position to pay 3 weeks of leave to all of their employees. Even those who worked for only a week before the shutdown, as 1306B would allow for. It seems to me to be impossible. Finally, I do appreciate the sponsor's acknowledgement about the overarching issue of leave, especially in the context of a health and economic crisis like the one we find ourselves in. If it is the will of the committee to move forward with this bill or the issue conceptually, it is imperative that any new leave, paid or unpaid, applies prospectively to any future states of emergency and not the current one. Throughout this session, the refrain has been to
Mike, can you finish it up?
Yes, sir, I'm wrapping up. Small businesses agree, and that is why we cannot pass a new leave law that saddles them with the increased costs as they are working their way back from an economic crisis none of us has lived through. For these reasons, NFIB opposes Senate Bill 727 and requests an unfavorable report. Thank you.
Okay, thank you so much for your testimony. Are there any questions for the witness? Okay, seeing no questions for the witness, we'll move to the next. Andrew Griffin, you have 2.5 minutes.
Thank you, Mr. Chairman and Mr. Vice Chairman and members of the committee. My name is Andrew Griffin. I'm here on behalf of the Maryland Chamber of Commerce, our more than 5,000 members and federated partners in opposition to Senate Bill 727 as introduced. So a lot of what has been touched on, I do not want to repeat. I will say you have our written testimony, which goes into detail the nuanced opposition that we have and the issues we see with the bill before you. So it's no surprise, the primary concern being the cost to employers. Obviously, like was touched on by my colleague at NFIB, the concern by small employers is obviously great. But when this bill was introduced, we heard from some of our medium-sized members, and I believe you have some written testimony from some of those members saying that if this bill were law during this current emergency, they likely would have gone out of business for good. And so I think those concerns are real, but to kind of take my lead from the vice chair, if we were to engage in some kind of a conversation about how this leave would be paid for, I know the chamber would be more than willing to engage in that conversation. We saw a lot of those things at the federal level, the FFCRA, what the vice chairman also talked about. I think maybe the posture that we would be taking here would be much different if that were part of the conversation. So I will just stop there to not repeat and say on the bill as introduced, we urge an unfavorable report. I'm happy to answer any questions that I can.
Thank you for your testimony. Do we have any questions for the witness? Okay, seeing none, we'll move on to Laura Howell. You have 2.5 minutes.
Good afternoon, Mr. Chairman and members of the committee. I'm Laura Howe with the Maryland Association of Community Services, representing developmental disability providers across Maryland. I'm here today in very respectful opposition to Senate Bill 727. I want to acknowledge the bill sponsor for his continued support of people with developmental disabilities and community providers and his sensitivity to the challenges that we face. Our written testimony outlines our concerns with the bill, and today I just want to speak to one section, and that is the removal of PRN staff from the exemption in the original safe and sick leave bill. This amendment was very important to DD providers when the original bill was passed, and it remains so today. I think most of you know we face a terrible workforce crisis, and we rely on PRN staff to provide staffing support when needed, typically on very short notice. They are offered shifts on an as-needed basis, and they can reject or accept the shifts they are offered. This is defined in the original statute, and it should be noted that it's different from temp staff. PRN staff are often offered full or part-time jobs with benefits by our providers, and they turn them down typically because they want an option that allows them the flexibility to work when they want and as much as they want. To offer mandatory sick leave to staff who choose to be PRN and have no responsibility to accept a shift would make this option very difficult to continue. This would effectively take away from DD providers and from PRN staff a win-win option. Agencies have PRN staff who know the agency and the people they support, which leads to better outcomes, and staff get the flexibility that they want. Without this, I'm sorry, I repeated myself. This would put added pressure on full and part-time staff who are already working enormous amounts of overtime and would decimate the fragile staffing safety net that currently exists for us. We are an industry that has long provided sick leave to our employees, and there is no shortage of jobs with benefits, including sick leave, in our field. We support a population of people who typically must have staff, and this change would upend the thoughtful balance that this committee worked so hard to create with the original bill. In closing, I want to thank you for your consideration of our concerns. I'm happy to answer any questions.
Okay, thank you so much for your testimony. Are there any questions for this witness? Okay, seeing none, Vice Chair Feldman, that concludes our hearings for the day. Is there anything that you wanted to add?
No, I think it's only 4:45. It's an early night for the committee, and we're going to move to adjourn and see everybody tomorrow. Enjoy your evening. I don't have anything else to say.